There's a lot going on in our world today, and I'm awfully glad that President Biden, a very remarkable president who stepped aside to allow Kamala Harris to take the torch and lead the nation, um, is doing a remarkable job still. And I guess this session would be called lame duck period. And what he's doing is enacting amendments and laws to help extend the Supreme Court. It is not just the predecessor that has upended our world, it's also the Supreme Court. And Clarence Thomas and Alito especially needs to be removed, along with John Roberts, because that's his crew. And John Roberts didn't do anything to get a hold of his crew, and he's only a justice in name only. So I will carry on. We have to stay focused on the issues. We all know who Donald Trump is, what he's done. We really don't have to mention his name, but we have to stay focused. And right now they're talking about Project 2025, but there's something that I want to bring to the forefront, and it's out there, but I've collected articles on the Chevron doctrine and all the things that this doctrine affects. Here's what the court's Chevron ruling could mean in everyday terms. The decision is expected to prompt a rush of litigation challenging regulations across the entire federal government, from food safety to environment. The Supreme Court decision on Friday to limit, and this is an older article, so it wasn't like this Friday, limited the broad regulatory authorities of federal agencies could lead to the elimination of weakening of thousands of rules on the environment, healthcare, workers' protection, food and drug safety, telecommunications, and the financial sector, and more. The decision is a majority victory in decades-long campaign by conservative activists to shrink the power of the federal government, limiting the reach and authority of what those activists call administrative state. That's the president and his gang. The court's opinions could make it easier for opponents of the federal regulations to challenge them in court, prompting a rush of new litigations while also injecting uncertainty into businesses and industries. The court was getting into the business of these other agencies that were experts that had control, and now they're saying that we don't want you to run the agencies. We'll run the agencies. We don't need your expertise. And I'm trying to sit here and figure out how can all these agencies be now ran by the judicial branch, which is supposed to be interpreting laws instead of judging from the bench, which they've just taken over, and making these calls. So that's yet to be seen. If Americans are worried about their drinking water, their health, their retirement account, discrimination on the job, if they fly a plane, drive a car, if they go outside and breathe the air you breathe, all these day-to-day activities are run through a massive universe of federal agencies' regulation. And this is stated by Lisa Heisling, an expert in administrative law at Georgetown University. And this decision now means that more of those regulations could be struck down by the courts. The doors are open. The courts will become the experts, which they are, I said, not experts in their own jobs. Look at the decision that they made on with the predecessor's immunity. That was just something that they've been wanting to do for years. So they had made up their mind a long time ago. That wasn't a decision that was just made today. So they've been basically plotting this for a long time. The decision effectively ends a legal precedent known as the Chevron Deference after a 1984 Supreme Court ruling. That decision held that when Congress passes a law that lacks specificity, okay, that's a hard word for me to pronounce, courts must give wide leeway to decisions made by the federal agencies charged with implicating that law. The theory was that scientists, economists, and other specialists at the agency have more expertise than judges in determining regulations, and that the executive branch is also more accountable to voters. I just, I can't wait. Well, that's just over the top. Because, like I said, they can't run their own ship, the Supreme Court. And I'm just trying to figure out, with their cases being backed up, and now they're going to take on all these cases. Like I said, our world is turned upside down. Since then, thousands of legal decisions have relied on the Chevron doctrine when challenges have been made to regulations stemming from laws like the 1938 Fair Labor Standards Act, the 1970 Clean Air Act, and 2010 Affordable Care Act, and others. In writing laws, Congress has frequently used open-ended directives such as ensuring the rule is the public interest, leaving it to agency experts to write rules to limit toxic smog, ensure that health plans cover basic medical services, ensure the safety of drug and cosmetics, and protect consumers from risky corporate financial behavior. But that gave too much power to unelected government officials, according to the conservatives who ran a coordinated multi-year campaign to end the Chevron doctrine. They believed the courts, not administrative agencies, should have the power to interpret statutes. So we're just going to cut out a branch. That's all it means. We don't no longer need three branches. Well, we really don't have three branches, because I don't really consider this MAGA Republican a branch, because I've never seen them really be problem solvers. Conflict and pure drama, absolutely, but not problem solvers. The effect has led Republican Attorney General, conservative legal activists, and their funders, several with ties to large corporations and supporters of former President Donald J. Trump. Overturning Chevron shares a goal of the conservative movement and the Trump administration. But yet and still, he doesn't know anything about Project 2025, and all through this paper is mentioning his name. Imagine that. It was expressed constantly, said Mandy Gunasakara, who, I messed that name up, I think is Gunasakara, who served as chief of staff of the EPA under President Trump and has helped write Project 2025. She served under him. He don't know nothing about it. But she served under him and she helped write it. Okay. So, a policy blueprint for the next Republican administration. It creates a massive opportunity for these regulations to be challenged, and it could galvanize additional momentum toward reining in the administrative state writ large if the administrative changes in November. So that means that we really got to get out there and vote, because if it changes in November, we're going to have big time changes, to the air that we breathe, to the water that we drink, to worker safety, and much more. Still, Jonathan Berry, who served as a senior Labor Department official under Mr. Trump, noted that overturning the Chevron doctrine itself doesn't immediately blow everything up. Yes, it does, because all these people are in Trump's camp, and he has admittedly over and over said he doesn't know anything about this, Project 2025, and this is a massive part of that. Rather, Mr. Berry said the fate of the regulations will be determined by what happens when they start moving through the courts without the protection of Chevron. The mystery. is exactly how much of this stuff goes down. It all goes to hell because if they're handling it on that side, which are not problem solvers, Mr. Barry, you know what's going down. Here's a look at how the decision might affect various government agencies. It affects the Environmental Protection Agency. Environmentalists fears that the end of the Chevron Doctrine will mean the elimination of hundreds of EPA rules aimed at limiting air, water pollution, protecting people from toxic chemicals, and especially tackling climate change. Over the past 6 months, the Biden administration has issued the most ambitious rule in the country's history aimed at cutting climate warming pollution from cars, trucks, power plants, oil, and gas wells. Without those rules, it would be very likely be possible for President Biden to achieve his goal of cutting greenhouse gas emission in half by the end of the decade, which analysts say all major economies must do to avoid the most deadly and catastrophic impacts of global warming. Just blow the world up. No regulations now. Just took it out. Just upended it. All of the Biden's climate rules have already been the target of lawsuits that are winding their way through the courts. Now, the court's going to have all these lawsuits, and they're going to run your air, your water, the cosmetics, right. So somebody else, they're going to bring other people in. And it's basically saying that, we just want our country to be ran like Vlad Vlad over there or somebody in China. So we might incorporate them in. I hate thinking about this. All of the Biden climate rules have already been the target of lawsuits that's winding their way through the courts. Legal experts say the reversal of Chevron will not remove EPA's foundational legal obligations to regulate climate warming pollution. That was explicitly detailed in a 2007 Supreme Court decision and in 2022 legislation passed by Democrats in anticipation of challenges to the authority. But the specific regulations, such as those designed to cut car, truck pollution by accelerating the transition to electric vehicles, that might be Elon Musk's part, or to slash power plant pollution with the use of costly carbon capture and sequestration technology, could now be more legally vulnerable. With the Republicans or MAGA, the Supreme Court, and Donald J. Trump, it is more than just vulnerable. The results will quite likely be the stringent climate rules designed to sharply reduce emissions could be replaced by much looser rules that cut far less pollution. Experts say that could also be the fate of existing rules on smog, clean water, and hazardous chemicals. And with that, like in Michigan, look what happened. And so this could bring on a terrible health crisis, a mental crisis, with the water being polluted like it was in Michigan. The labor agencies. The elimination of Chevron Deference could affect workers in a variety of ways, making it harder for the government to enact workplace safety regulations and enforce minimum wage and overtime rules. One recent example was in April when the Biden administration raised the salary level below which salary workers automatically become eligible for time and a half overtime pay to nearly $59,000 per year from about $35,000 beginning in January, which Elon Musk could have got out of his pocket and gave everybody a raise, paid their salary probably for a lifetime. There you go. Big business. Business groups have challenged the Labor Department authority to set a so-called salary threshold, and such challenges will have a far better odds of success without the Chevron precedent, expert says. Now, who are those experts working for? They gotta be kidding. The shift could also rein in protection for workers who publicly challenges the policies of their employees, according to the Charlotte Gordon, a professor of labor law at the University of Minnesota. The National Labor Regulation Board often concludes that a single worker has the right to protest low pay or harassment or attendance policies without being disciplined or fired. You know, if they reach out, retaliate, speak their mind, and write the work takes, you right to fire. They're going to get fired. But because they don't have a voice. But the relevant law refers to concerted activities, meaning the protection may not apply only to groups or employees who stage such protests, not individuals, Professor Gordon said. How it affects the Food and Drug Administration. The Food and Drug Administration flexes significant power when it set the standards for how new drugs must be studied and whether they are safe and effective before they are approved for use. Ooh, a health crisis. You can see it coming. And you can see us being used as guinea pigs. And basically saying, just like the medication have side effects, whatever happens to the person that's taking the medication, they're not going to claim that it's their fault. It's going to be your fault because you had the disease. You didn't eat right. But they never came forth and said how to problem solve or help us with the underlying problems. They're only surface problems that they handle with a bandage. Attorneys who worked at the agency said the company's chafing at the high bar for approval might now challenge those regulations. Others said legal challenges could ultimately affect drug prices. Challenges are also expected in the agency tobacco division, which authorized the sale of new cigarettes and e-cigarettes with an intent to protect public health. I would expect the industry to attack the FDA's authority to do pre-market pre-review at all, said Desmond Jensen, Deputy Director of the Commercial Tobacco Control Program at the Public Health Law Center. It's strange how you got cigarettes and it's connected to public health. The word health and cigarettes, it just don't seem to match up. And we know how that went for years when they didn't even want to put a warning sign on the side of a pack of cigarettes. Others noted that the Chevron decision could have a chilling effect. The whole Chevron decision and Project 2025 has more than a chilling effect, compelling the FDA to proceed quite carefully given the potential for litigation. It is moved forward with proposals to ban menthol cigarettes or make them less addictive by slashing nicotine levels. We're back in the 60, 70. That's this sound like just yesterday. Abortion opponents said that the ruling could work in their favor as they seek to bring another case against the Food and Drug Administration approval of an abortion medication to the Supreme Court, which rejected their effort to undo the agency approval of the drug this month. Crystal Hamrick, a strategist for the Students for Life of America and anti-abortion organization, said that in a statement that such a case was likely to get a better reception when the FDA is no longer given the benefit of the doubt. We'll move on to health care. The court's ruling could affect how Medicare, Medicaid, and the Affordable Care Act insurance plans are administered. Health laws experts said as opponents gain an opportunity to challenge how those huge programs operate. The healthcare system is governed by elaborate regulations covering how hospitals operate, what providers are paid for medical services, and how insurance companies are monitored by the government. Much of that regulation is grounded in interpretation of laws that date back decades. Major industries could be affected if rules are changed. We don't have to worry about that because the rules have been changed. There's an awful lot of regulation that flies under the radar that's just about making sure the train runs on time. The train has left the track, said Nicholas Bagby, a law professor at the University of Michigan. Rachel Sach, a health law expert at the Washington University School of Law in St. Louis, said that the complex set of rules devised and governed by the Department of Health and Human Services and the Center for Medicare and Medicaid Services could be challenged in new ways. They've done everything they can to get rid of Medicaid, Medicare, the Affordable Care Act, whatever act that they could get rid of, that's what they're trying to do. There's a lot of work to do in this process, she said, and therefore there's a lot of opportunities for challengers to pick at specific choices that the CMHS and the HHS are making an interpretation of these rules. The Supreme Court decision will require Congress to specify exactly what agencies like the CDC can and cannot do, several analysis said. Nobody has any confidence that Congress can get another act together to do that, said Dr. George C. Benjamin, executive director of the American Public Health Association. You heard the Speaker of the House, what he says. Anything that comes through there is dead on arrival. We don't have confidence in that MAGA Republican. No, that needs to be changed also. I think the decision as written solidifies employment for lawyers and judges and undermines the authority of experts, he added. He said a mouthful. Now we got Supreme Court that's now going to be the experts in food and drug, the healthcare field, climate change, unreal. Unreal. And they're going to be deciding what? When they can't not only pronounce some of the words, let alone spell them, you know that they cannot interpret science. They're not scientists. They're not the experts. Other scientists also expressed doubt that Congress of the judiciary could remain abreast of constantly evolving scientific evidence to keep up with that pace of change, even for a medical or scientific profession, is very challenging. Now, it's challenging to the scientists, so you know it's going to be challenging to them, and it's not even in their field. What is the saying? They, the Supreme Court, did not stay in their lane. Karen Newsom, a chief executive of the American Cancer Society. Whoa. The Biden administration has written health regulations anticipating a world without the Chevron Deference, said Abby R. Gluck, a health law expert at Yale Law School, who serves in the White House at the beginning of Mr. Biden's term. And for that reason, she thinks litigations over the most recent rules may be less influenced by this change than challenges concerning some older regulation. The Supreme Court has not relied on Chevron in quite a few years, she said, so the federal government, includes HHS, has become accustomed to drafting regulations and making its interpretation argument as if Chevron did not exist. They've already adjusted, Mr. Gluck said. Of course, the question is, who does Mr. Gluck work for? The Treasury and Internal Revenue Service, another agency that it's many agencies that's going to be affected, but just hitting on a few. The Treasury Department and the Internal Revenue Service both have broad mandates to interpret the legislature when they write rules and regulations enforce the tax code. To the big business, the poor will be poor, and the rich will get richer. And the Elon Musks and all the billionaires that has decided to come on over to Trump's side, this is what they want. This is exactly what they want. Since the Inflation Reduction Act passed at 2022, the Treasury Department has been racing to roll out regulation related to billions of dollars of clean energy tax credits that provide huge incentives for things such as the manufacturing of batteries, or the purchase of electric vehicles. The Treasury Department has received pushback from some lawmakers who contend that it has not followed the intent of law. They ain't followed the intent of law. They don't follow the rule of law. They figure like the hell with the laws. We the law now. Although Congress creates the tax code through legislation, the IRS has wide latitude in how the tax laws are administered. According to experts, have suggested that the court's ruling could complicate the agency's ability to administer the tax code, without specific direction from Congress. It would be nice if we could leave MAGA out. It would really be nice. A recent example of how the agencies last year delayed enforcement of continuous tax policy that would require users of digital wallets and e-commerce platforms to report small transactions. The new provision has introduced in Tax Code 2021, but was strongly opposed by lobbyists and small businesses. The IRS received criticism from some lawmakers for delaying the policy, but the agency defended its decision by arguing that the tax code needed a longer transitional period, whether the measure should be enforced to avoid a chaotic tax erosion or tax erosion season. Okay, so that was one of the articles I found. I found several articles on Chevron decision and agencies, the effect that it have. This doctrine, it was established by the Supreme Court decision, USA Incorporation, Natural Resources Defense Council Incorporated in 1984, essentially provides a framework of how the court should review agency interpretation and statutes. In essence, it states that a statute is ambiguous. Courts should defer it to an agency reasonable interpretation of the statute. So what this basically states is, when they up in this Chevron, all of these agencies are gonna suffer. And now that they are everything that they went to school for, studied for, or have expertise, they don't need those expertise. What they want to do is take all that power away from the government system that we have enforced, and bring it to a more anarchy, dictatorship, control strictly to the Supreme Courts, who made all these rules and now have went in and upended and snatched all these rules, and is definitely trying to put us back into the late 60s, early, just as they say, back in the day. That's why I don't like using the term back in the day, because it's a struggle. We have a struggle moving forward. But I will continue on Chevron doctrine or deference, and it really affects a lot. So we got to stay focused on 2025, and please read. I'm asking all the young people, if it's difficult for you to read, try auditory equipment like Amazon, like this on Amazon, and the major thing is, it's no way you can pass through life without being informed. This is your world and your kids' future world, my world, and the bottom line is, as we grow younger or as we get older, me being just a little sarcastic there, and we are faced with our mortality, we want our children, grandkids, future generations to have the things that we didn't have. And a lot of those things have been taken away from from you guys. And so in order to get that back, you have to go in and, like I say, stay focused, read, get in a group, try to find out as much information as you possibly can, because this is so important to your world, for your world to continue, for your children, and the generations to come. I know that when we're young, we pay less attention to things because it doesn't matter, but it does matter. Your life matters. And once again, I will get more information on, and I do have more information, but just on this particular document that I found, I wanted a lot of people to just kind of know that this is really important. And please stay focused. Please pay attention. And most of all, please read. Please read. It is important that you know as much about everything that is going on with the predecessor, the Supreme Court, the things that President Biden is trying to put in place before he goes out, the election. You have to ask yourself the question, what kind of world you want to live in? And once you get granted the world that you live in, there's so much that you have to fight for. So on that note, I'm going to end this video, and I thank you for coming and listening, and I'm out.